2024 CR 006945A, State versus Angles, Uncles Talbot. Could I have parties announced?
Jason Garrett for the state.
Scott McCrum for Mr. Uncles Talbot.
And are you Mr. Uncles Talbot?
Yes, ma'am.
Is that how you pronounce your middle name?
Ockles.
Uncles.
There's two last names.
All right. Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Mr. Uncles Talbot, did you review the true bill of indictment with your attorney?
Quick legal check-in. When the judge asks if the defendant reviewed the indictment and understood it, this is about confirming the defendant was fully informed of the charges. It's a crucial due process step, even if it feels routine.
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge with range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine?
Yes, ma'am.
This right here is where the stakes get real. 5 to 99 years or life. Notice how the judge makes it crystal clear. If she rejects a plea deal, the defendant can walk it back. It's her way of making sure no one can claim they were blindsided later.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
And there it is. The plea deal, 30 years. Plus, an affirmative finding of a deadly weapon, which means he'll have to serve at least half before even being considered for parole. That's 15 years minimum. No parole board sympathy until then.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Uncles Talbot, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 30 years in the prison. There's an affirmative finding of deadly weapon and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
No objection.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, we'll start again. So the court is finding that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulation. Court will accept into evidence State's Exhibits 1 and attachments without objection, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, the court will follow your agreement, sentence you to 30 years in the prison. There's an affirmative finding of deadly weapon, and the court will give you credit for any time served.
This part's easy to miss, but heavy in impact. The judge just sentenced him, and now she shifts gears. Not just legal consequences, but life consequences. Her message? You might walk out someday, but someone else never will.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand and sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so what date do you all want to bring this back for victim impact?
Judge, at this point, the state would be requesting July 29th, which is 1 week from today, to allocate for the victims.
That works for me, Judge.
All right, if you'll put a hold on him, please, for July 29th. We can go off the record. Sir, here's the thing. 30 years is a lot of time. And with you, you're going to have to do half the time before you're even eligible for parole. While you're there, you need to make some changes in your life. If you don't, what's going to end up happening is at some point you're going to be released, right? Either you're going to end up serving the full 30 years, and if you serve the full 30 years, you'll still have more life ahead of you.
And now we get the full picture. The crime? A deadly drug deal gone bad. Two suspects lured the victim through social media, met at a park, then allegedly came back and shot him. The courtroom formality you just watched? That's the backstory playing out in real life.
The person that was killed, they have no more life ahead of them. You understand? So, while you're doing your time, sit and think about what you've done wrong in your life and how you can change things to be a better person. You understand?
Yes, ma'am.
All right. Good luck to you. We'll bring you back on the 29th.
Arrest that happened at Pearsall Park. 26-year-old Jacob Kawazo was arrested on a couch this afternoon on the far north side. Kawazo is believed to be from the Plano area. He's accused of shooting 23-year-old Juan Guerra during a drug deal back on December 14th. Another suspect, 32-year-old Angus Ockles Talbot, was arrested Monday. Police say the two suspects were communicating with the victim through social media and text. They reportedly met the victim at the park around 9 p.m., but said they had to go get money from an ATM.